if you've got your son listed on your account and then he goes and gets in trouble, he's got creditors going after him, he's needing to file for bankruptcy, he's whatever happens to have happened, these people who have a judgment against him, they're going to go look for his assets. And if his name is on your account, those creditors are going to be going after your account, even though he's not the one putting the money into that account.
Right. So it can be dangerous.
Yeah, I'd say that's very dangerous.
Starting your route to retirement.
Welcome to the Guided Retirement Show. I'm your host, Dean Barber. Special guest today, Tim Denker of the Denker Law Firm. We're going to be talking about estate planning mistakes to avoid. You do not want to miss one moment of this episode. Please enjoy my conversation with Tim Denker. All right, Tim Denker, Denker Law Firm. Welcome to the Guided Retirement Show. Thanks for being here.
Yeah, absolutely. I appreciate you guys having me.
Absolutely. So we're going to talk about estate planning mistakes to avoid. You've been doing estate planning now for almost 18 years.
Yep.
And so I'm sure that you've seen some mistakes out there and things that people could have avoided had they been informed.
Sure, I definitely have. And I mean, honestly, what you kind of run into is the very first biggest mistake people hit is that they don't do anything at all.
Yeah.
And so what happens is if you do nothing, you just kind of let everything go, then you've got state laws that are in place that are going to dictate and tell you what the court is going to do with your stuff. And when that comes into play, whether you're Missouri, Kansas, or whatever state you're going to be in, the probate court is going to cost your family a lot of money. It's going to cost them a lot of time, and it's going to be a big headache.
Plus, it's public.
Plus, it's all public record.
Yeah.
Yep. Especially more so in some of these states as they continue to put a lot of those records back out there.
Right. I always tell people, you have an estate plan, whether you know it or not, because the states are going to make your estate plan for you. Have you not done something on your own, either a will-based estate plan or a trust-based estate plan? Something's going to be in place for you because somebody has to decide where your stuff's going to go whenever you're not here any longer. And if you haven't laid that out very clearly, the courts are going to step in and decide for you.
They definitely will. And honestly, if you're not paying attention and you don't really notice how your assets are actually titled, you could be in your first marriage, you have kids together, but not everything actually goes to your spouse because you'll have things that are just in your name that are not in their name, whether it's a retirement account or whether you went and bought a car one day and your spouse wasn't with you. And then all of a sudden they're not on the title and then they have to go deal with the DMV to get things done if something happens to you.
Not fun. So the biggest mistake is not preparing an estate plan.
100%.
All right. So let's go to think what I think is a misnomer, and people think that your last will and testament, your will, is a proper estate planning tool, not understanding that just like all dogs go to heaven, all wills have to go through probate. So if you have a will-based estate plan, you're going to be forced into probate once again.
Correct, if it's not done correctly. So kind of what I coach all of my clients on is first, everybody should have a will, but the goal of the will is to catch what slips through the cracks. And what is slipping through the cracks is above that will, you've got this non-probate planning device into place, whether it's the use of what's called a trust, which I think we'll get into, or if you're just going around and you're doing the different titling of your assets. So you go get just a will package, a will plan that's got the power of attorneys or whatever else you're going to need. That will is, hey, this is what my plan is, but then there's some more intense titling and things that you need to go do and you need to stay on top of as life progresses to make sure that the will is not actually what is going to control the distribution, because if that will takes place, it's like what you said, we're in probate court at that point in time because that's the only thing the will actually controls.
And I don't think most people understand that, Tim. I think that they think, well, I got my will done and it says what I want. Why do I have to have a judge read it to say that's what you really intended?
Right. Yeah. And there's a good reason for having those judges in place and making sure that the creditors and the beneficiaries and everybody are actually protected. But yeah, it's still one of those things that if you can avoid it, in my opinion, 99.9% of the time you actually do want to avoid it.
So when you talk about proper titling really quickly, so you've got an estate that's not too large and you have a will to catch those things. Then you title as transfer on death or pay on death, but that's got to be on all of your assets, right? It's got to be on your bank accounts. It's got to be on your automobiles. It's got to be on your real estate. Whatever real assets you own has to be titled with a transfer on death or a pay on death, or it has to be titled jointly, but there's some dangers in titling jointly with your next generation, if you will.
Correct. Yeah. So the one thing that people sometimes don't understand is that you can go create this plan inside your will, and then you can go title your assets. And then I'll have people say, well, I added my son to my account so he could help me handle it. And then I have to get into, well, is he a signer on the account? Is he a joint owner on the account? Did you list him as a beneficiary or a TOD? How did you actually do it? Because they think that, well, when I die, the will is still going to take effect and it's going to control what those distributions are. And that's not actually true. Like, the will is not going to circumvent the planning that you do with the titling of your assets. The titling of your assets is what is actually going to control everything.
Right. So talk about the dangers really quickly of adding your child on as a joint owner on your account.
So there are two primary dangers that I see in that taking place. And the first one is what I think is obvious, but I think a lot of people overlook, is if you've got multiple kids or multiple people you want to leave your money to or your inheritance to, once you list one child on that account with you, what happens is when you die, that account is automatically going to transfer to that child. They have no obligation. They have no requirement. Nobody can come in and force them to share that money with anybody else. So a lot of times what that does is, while it gives that kid a convenience of being able to access the account and help their parent out during their life if they need it, or even if they don't need it, just to help out anyway, it still undoes the planning, or it doesn't allow them to have their wishes actually carried out. So the other thing that I actually see on that comes down to more of a liability thing.
Right.
So if you've got your son listed on your account and then he goes and gets in trouble, he's got creditors going after him, he's needing to file for bankruptcy, he's whatever happens to have happened. Well, what happens is these people who have a judgment against him, they're going to go look for his assets. And if his name is on your account, those creditors are going to be going after your account, even though he's not the one putting the money into that account.
Right. So it can be dangerous.
I'd say that's very dangerous.
Yeah.
So oftentimes what we do look at is we do try to say, hey, don't add him as a joint owner on the account. Use your power of attorneys that have been put into place for you, or add them as a signer only on the account, which is kind of that bank's internal power of attorney, I guess you could call it.
So I think we've kind of killed the whole will-based planning as a, if you do it, make sure that you know what all the extra things you have to do are. Otherwise, it may not be sufficient.
Right. Yeah, I would say that is 100% correct.
So let's go into the trust planning really quickly. And I know that there's a mistake that comes along in trust planning, or there's actually a lot of mistakes that can happen in trust planning. But let's talk about what a trust is for. And I think, first of all, I think a trust has two purposes, and you may come up with more than me, but a trust is to both make sure that your wishes are carried out while you're alive and after you've passed on. So I think the trust really has a dual purpose, and that's why they call it a living trust.
Yes. And I would agree with you. And when you get into a trust, what you have to understand, there are so many different types of trusts that are out there that for you to narrow it down to the 2 points that you made for what it actually is, I think that gives a good summary of what all the trust general purposes are for. But there are so many different things that you can actually do with a trust that we could have conversation for a few hours about talking all the different types of trusts that are actually out there.
So then, would you consider people just going online to LegalZoom or whatever and saying, oh, hey, I'm going to go create my own trust?
I would absolutely not recommend that. But of course, I come from a fairly biased standpoint, but I'm also very educated on what the trust actually does. So when you think about what a trust is, it's, to kind of simplify things, it's this massive contract. And you're talking about something that could be anywhere from the older trusts, I've seen them be around 10 to 15 pages, to you could get them extremely complicated to get 40, 50 or more pages, depending on how complicated tax strategies and those kind of things are going to be inside that trust. And so when I think of somebody going online and going and printing off this 20, 30 page document, just to give you an average number of pages, and then to not understand what all the words mean in it, or why certain provisions are in there, or if something is missing, I'm flabbergasted. I'm just like, how in the world do you go sign that document because you read some blog or you heard some person online that you don't even know whether they're an attorney that said, hey, this is a really good idea for your family. And then once you have it, do you even know how to use it? And
Right.
so why would you not want to have people or professionals that are in place to coach you and to teach you how you should be using this trust to best benefit you and your family?
I think you would. I mean, I think it's dangerous. I think it's, to me, it's no different than somebody saying, well, I just go get TurboTax and I'll do my own taxes, right? Well, I'll do my own will or my own trust, or I'll do my own investing. And look, nobody's saying that you can't do those things, but it's the things that you don't know that get you in trouble, right?
Yep.
And that's why we all have professions, and that's why people rely on us.
Right. And honestly, I've played with things like that about trying to figure out, can I go streamline trusts and can I go get them out on the internet so people can do it, save money, not have to have the legal advice and things like that. And I think if you do something like that, more than likely the person that's doing it's going to have to get pigeonholed into something that doesn't necessarily fit their situation. It's what I kind of call fitting a round peg into a square hole. Like, hey, it might fit, but you're going to be missing some of the stuff that you could be using to actually benefit yourself.
So that goes to one of the mistakes that we think is out there, and it's not getting the right people involved. And depending upon the complexity of your overall financial situation, I think that if you start with the certified financial planner that clearly outlines what is the long-term objective of this family, then we can bring in the CPA and the estate planning attorney, and collectively we can talk about what's the best thing to do from an overall financial planning standpoint, from a tax planning standpoint, and from an asset transfer and asset protection standpoint, right? And so you have all three of those experts involved, the CFP, the CPA, and the estate planning attorney. And when you come and work collectively like that, there's a lot of things that get done right that would have otherwise been missed.
Yeah, there definitely are. I mean, what you kind of craft in that situation is you craft your family's own little board of directors. You go find these people who are experts in what they do, and you say, hey, make my situation the best that it can possibly be, as opposed to going and figuring those things out for yourself.
One of the things that I see happening often, Tim, and which is one of the reasons why, here in Modern Wealth, we have, we understand the estate planning. We've got the expertise. You will sit side by side with the CFP here at Modern Wealth and say, here's what we need to do. We got the CPAs. A lot of times, if you don't have an organization like that can bring all of those professionals together under one roof on behalf of that client, the attorney speaks a different language than the CPA, and the CPA speaks a different language than the attorney and the CFP. And so a lot of times the individual is left in the middle trying to decipher what it is that these three professionals are telling them. So bringing them together collectively to actually work together is really an important factor.
It is. And honestly, I think some of my best initial meetings come when I've got the CFP in the office with me, because I'll give this big 9-10 page questionnaire for people to fill out. Well, oftentimes I'll learn that they're going to fill it out to tell me the things that they think that I want to know, as opposed to telling me everything.
Right.
And figuring out how things are titled where they say, what do you mean? Or oh, I have no idea. And being able to look at the screen behind us and have one of your CFPs sitting there and saying, well, this is what we've done in the past, and here's what your accounts are. It really helps lend to the conversation to make sure that we can have the best plan that we possibly can put into place for them.
Absolutely. The thing that I think that when I look at an estate plan, I always think it's not for you. It's not for the individual that's crafting the trust. It's for your family. Mm-hmm. And, if you care about your family, you ought to have a conversation with an estate planning attorney, a CFP, a CPA, about how do I make sure that if I'm incapable of making decisions, or if I'm no longer here, that everything gets done the way that I want it to. Because I've seen some train wrecks happen and some real horror stories where, somebody goes and they did the trust, but they didn't update beneficiaries on retirement accounts. Had one scenario, and I'm sure you've seen this before, and we're going to talk about this, that not understanding that IRAs and 401ks are different. Mm-hmm. That's a huge mistake. Had a scenario where an individual had lost a spouse, and renamed his 2 children as beneficiaries on his 401k. Several years later, got remarried, and within about a year of that remarriage, he passed away, and his 2 children were still beneficiaries on his 401k account, which is what he wanted, but it didn't happen that way because of the ERISA laws. And the new spouse, even though they'd only been married a year, didn't sign the spousal waiver waiving her rights to that 401k. And so unfortunately, even though he thought he had done it all right, all the money in that 401k went to the new spouse, and the kids lost in court because contract law.
Yep. No, and I think when it comes down to it, estate planning is probably one of the most unselfish things, or it's one of the most unselfish things that you can do. You're never going to realize any sort of gain out of the stuff that I put together for you, outside of maybe you get some sort of personal sense of relief that it's done and your family is going to be taken care of. But honestly, the clients that I deal with that have that sense of relief are the clients who have dealt with it in the past. And they said, yeah, my dad passed away. He didn't get anything in place. And it was just an absolute mess from the get-go. And it took us 3 years to get this resolved. And just, you get all the horror stories and those kind of things that kind of come out of that stuff. So, but like every person that is out there, anytime you have a change to your person, your place, or your property, you really need to be reviewing it. And that's divorce, that's bankruptcy, there's life, there's death. All of these different scenarios take place. And it's like you were saying with the 401k is, look, you just got married and you didn't do anything with your estate plan. There's no guarantee what is going to happen to me when I walk out the door today after we record this. I don't know what's going to happen with the driver that's going down the road or anything. So I can't go plan 10 and 15 years into the future or say, hey, I'm going to put this off and I'm going to get to it down the line, maybe when it's just a more convenient time for me. Because look, you're not a fortune teller. I'm not either. None of us are going to be able to tell you exactly when we're going to be here the next day.
No, yeah, you're exactly right. And we've seen those things happen. Mm-hmm. It's interesting because, I've always had an estate plan, and my wife and I were talking here earlier this year, and she said, we need to get our estate plan updated. I'm like, we just did that a couple of years ago. She goes, I think it's been longer than that. So we contacted the attorney that did our estate plan and said, hey, we want to sit down and review things and make sure that everything's up to date. And when we got into the meeting with him, I said, how long ago did we review this? He goes, it's been 6 years. I'm like, oh my gosh, 6 years. Well, that 6 years flew by. And I think that's another mistake that people make, is thinking that once they did it, it's done.
Yeah.
But laws change and rules change. And so I think it's important that people review the estate plan that they have at least every other year.
Oh, yeah. I mean, and even if you know what your trust says and you know exactly what's going on, you still need to figure out how your assets are actually titled. Most people don't remember exactly what they did. And like I'd mentioned the car earlier, when you talk about the things that slip into probate, people buy cars and they totally forget to go add it to the trust or to TOD it to their kids or something to that effect. And it's just all these different assets and the things that you buy that you don't really think about. Or, well, I've got this account that I've had at this credit union for years and years. There's not very much in it. Well, the one thing that people don't realize is in a lot of the states, the probate court does not care how much your assets are worth. Something still has to take place to get them to advance on. Kansas has some fairly good leniency on those smaller estates to help people get things through, but not if it's regarding real estate or anything like that. So there's little things that everybody has to take into consideration, and they have to continue to look at to make sure that it is still carrying out their plan, because it never hurts to double or triple check something.
No, I think you're exactly right. I mean, again, there's stories after stories after stories. We one of our advisors here had a scenario in the last couple of years that the older clients, mom and dad, had done a trust. And so we went through and retitled everything here in the name of the trust, and mom and dad pass away. Well, there was 2 accounts that totaled over $2 million that client never told us about. So we didn't know they existed, but they never put that money into the trust. They never retitled those accounts into the trust. And so unfortunately, even though mom and dad had done a good job and we did everything we were supposed to do here, now we have over $2 million that's going to go through probate because there is no trust.
Yeah.
And there was no proper titling. It was just joint tenants with right of survivorship.
Yep. And probate's not cheap. I mean, if you take one of those through Missouri, we have minimum percentages as far as what the attorney, what the personal representative, everybody are entitled to get paid. And I've never done the calculation on a $2 million estate. But I mean, you get up there and you start talking about a very significant amount of money that you were paying out that you wouldn't have had to do if you would have just taken an extra 30 minutes to go get something done.
Yeah. Is it 5-6%? I mean, I know all states are different, but
so Missouri is a sliding scale that starts at 5% of the first 5,000, 4% of the next 20,000, 3% of the next 75,000, 2.75% of the next 300,000. It just kind of goes like that. But a lot of times, what you'll see is attorneys will come in and they'll say, "Hey, I'll do this on a flat 3% or whatever the case may be," because as a minimum fee, that you can always have the hourly fee exceed that fee. And I'm currently $3.25 an hour. I'm not the most expensive guy out there. I'm not the cheapest one out there. But when you start having somebody work on something that takes hours and hours of work, it adds up really, really fast, especially when you're dealing with the courts and if the family starts fighting and if you have all these additional hearings and all these different things come into play, you get up to those numbers pretty quickly.
You know, here's what I would encourage people to do is to, if you haven't done your estate plan, you can get a conversation started with our team here and, really understand what needs to happen. And I think every single person's got a different scenario. I mean, how many estate plans have you done that look exactly the same?
Not that many. Every one of them's got its own unique twist to it.
Right. And I think that's really the key. Everybody's estate plan should be unique to their own personal situation.
Yep, they really should. And honestly, and a lot of that stuff comes into play. The situation is not just what your wishes are. The situation also takes into consideration who the beneficiaries are.
Yeah. Let's talk a little bit about, there's a lot of small business owners out there. Mm-hmm. And those small business owners oftentimes don't have any type of succession plan. And they don't understand the dangers that are facing them in the event that something happens to them, either incapacity or death. And you can kill a small business. You can get really raked over the coals with excess taxes. I mean, all kinds of things can happen. So when you're working with a small business owner, you got to go further than just the trust document, right?
You do. You really do. And so what I think a lot of small business owners plan but don't necessarily do anything about is making sure that they treat their business as a separate asset of the estate. Your business, just like your house, just like your retirement account, is all the things that you are investing in. In this situation, you're putting money back into it. You're putting your time into it. It is going to be the greatest return on investment that you can get if everything goes well. There's nothing that is in the stock market that's going to beat what you're going to do in a small business. But what a lot of people don't realize is it's not just your paycheck during your life. It's not how you're supporting your family. It's also your retirement plan. It is that nest egg that you're going to create if leaving an inheritance is important to you. So building this business up and having these things that you can go sell one day are extremely important to do, because what you're doing is you are planning for the succession of your business. If something happens to you, what is going to happen to that business? Are the employees going to lose their jobs? Is the business going to get shut down? What's going to happen with the landlord? Do you own the building? There are so many different factors that can come into play. And business owners really need to start thinking these things through. Do I have a key employee who might want to buy me out? Or is there a competing business? Or is there a friend? Or do I have kids that want to take this over? Is it going to be a family business? And then how does that tie into my retirement plan? Like, if I'm going to have this business and I'm going to have my kid take it over, do they have to buy me out? Do I have multiple kids? One of them doesn't want to be involved. I mean, there are so many factors that can come into play. And then when you go look at it a little bit further, it's like, all right, well, when this happens and there's this transfer that takes place, how do I minimize the tax impact on me and my family to be able to make sure that this is done in the most efficient way possible?
Yeah, big deal. I mean, I personally think that from a financial planner's standpoint, financial planning for a small business owner is probably the most difficult person that you can do financial planning for. And I think estate planning for the small business owner is the most difficult estate planning you should do, because there are so many different moving parts and so many complexities to it.
Mm-hmm. And you know, the one thing that I'm going to come back into the trust a little bit on this one. I think that anybody who's a small business owner would benefit greatly from having a trust, because at the very least, it's going to be able to have you put a person in the position, which is a trustee in this situation, to be able to step in and at least manage what's happening in the business in the meantime, so things can get figured out if you don't get something else in place.
So that brings up another mistake that I think people make. And I know that if you're coaching somebody through the estate planning process, you can talk to them about this. But if they're trying to do the cheap legal advice online, they're going to miss it. Some people might say, well, I'll just name my oldest daughter or my oldest son as the successor trustee should my wife and I not be able to take care of our own affairs. Or if we're both gone, that successor trustee is going to be the one that's responsible for the distribution of the estate. People don't understand that they're putting that individual in the capacity of a fiduciary and that there are very strict rules that have to be followed. And it's a lot of work that needs to be done. And they don't consider, this is the mistake, they don't consider a corporate trustee to act on their behalf when they're no longer able to. And they think, well, that's just too expensive. What are your thoughts?
I think the corporate trustee can play a very important role and they can be a very good fit. I also do like the family dynamic of having somebody who has an intimate familiarity with the actual estate to be able to handle it. But like you said, it's a massive amount of work. So oftentimes I will have clients that will draft in provisions to say, look, if this person is serving as the trustee, they're going to get paid for it. And so we'll usually at the very least leave some sort of reasonable fee. So it'll take into consideration the nature of the assets and the work that needs to be done. But understanding that it's not one of those things that you make a couple of calls and it's just completely done. I mean, there's a lot of work that goes into that stuff.
Yeah, I like to say, okay, if we want the family dynamic, let's go ahead and name one of the children as the successor trustees, but let's give them the ability to opt out.
Right.
To say, no, I want to remove myself. Well, who's the backup after that? That's where the corporate trustee can come in.
Yep.
Right. If that individual looks at this and like, I don't have the capacity to do this, I'm going to step aside and let's bring the corporate trustee in.
And the corporate trustee can also protect from fighting. I
Yeah.
mean, so you go and you just say, hey, I want to name the oldest to be serving as the trustee because they've got a good head on their shoulders. They know what's going on. Well, they may have two siblings and those two siblings don't necessarily agree with what the oldest is saying. And you may have people that never talk again.
Yeah.
I mean, death and money do crazy things to people and how they act. It just completely reverses the way that you would think things would actually occur sometimes. And so going ahead and saying, hey, let's have this corporate trustee handle this for us allows the families to still be able to maintain the levied relationship that they had before.
Most people, I believe, want their money to follow the family bloodline, right? They don't want it going off to somebody that they never knew. But if you don't craft the trust in such a way where it can create a beneficiary controlled trust for the ultimate beneficiaries of the trust, there is the danger that that money gets in the hands of somebody outside of the family. So talk a little bit about that beneficiary controlled trust and why that might be a good idea.
Yeah, and so kind of we'll start at some of the protections the trust can put into place for a family is when you go craft these documents and you're going to say, hey, I want the inheritance to be split equally between my children. And you can basically just say at that point in time and then just have it distributed out. Well, one of the benefits of a trust is that it allows control. And so it's kind of that controlling from the grave, so to speak, but you can also protect them from themselves. But you can go put provisions in that basically are saying, hey, you're not going to get access to the money until this event occurs. Oftentimes people might try to tie it with age. They might tie it to some sort of like requirement, like you have to go get a college education. Or, I mean, when you see those movies where somebody has to go get married or something like that, you can do something silly like that. So there's a lot of control things that you can put into these trusts. And with that control, say, for example, you're saying, hey, we're not going to leave you any property until you were 75 years old or you're never going to get it. It's going to be held in trust on your benefit. Provisions can be put into place to say, hey, you could have access to this money, but it's going to be at this trustee's discretion. While it sits inside the trust and it's at somebody else's discretion, you don't have what I'm going to call a mandatory distribution coming to you. Basically, you have shielded it from creditors. And when I say creditors, I'm not just talking about some credit card company that's suing you or somebody because you got in an accident and didn't carry enough insurance. I'm talking about other people in your life. You've got the risk of divorce. You've got bad marriages and those kind of things that can come into play. And you can go put your kids into a position to where they can inherit these assets. They can get access to them to a certain extent, But at the same time, they're not going to have full access to where it can be accessible to creditors. It can be accessible to commingling, to where it goes to a spouse that they're divorced a year later. I mean, there's a lot of these different scenarios that could come into play.
Yeah, and even, Tim, what I've seen, which is the real horror story, when that's not done, let's say that you have a child and we'll just call them in their 50s when they inherit money. They're married, and within a couple of years after inheriting the money, something happens and the child passes away. Well, now the spouse of that child has the assets, right? They get remarried. They pass. Where's the money go? To some person that never was part of the situation, and what happens is their kids get left out.
Correct.
Right?
Yep.
And so that's where this whole, making sure that trust takes it all the way down through generations so that the money actually goes where you want it to, not to somebody that you never knew.
Right. It does. So the one catch that you kind of run into that is a lot of times people will want to say, hey, I want my kids to have it, but I want my kids to manage it as well. And so they're going to maybe name their kids as the trustee and as the beneficiary. The one thing you have to be careful about on something like that is if they're not handling things correctly, if they're in the wrong state, if the laws change, or if there's different court interpretations of what's going on, if they're filling both roles, you always have the risk that somebody's going to basically be able to come in and what I'm going to call pierce the veil and say, hey, this trust is really just your alter ego. Like, we're going to go ahead and let them go after these assets because there's not really a trust here to begin with. You're just using this as this sort of fraudulent shell to hide behind and protect those assets. So you do have to be careful about how you structure those. And when I have had that conversation with clients in the past, I will get pushback sometimes from either the client or you'll eventually get it from the beneficiary at some point in time because they're like, if you want to leave me the money, leave me the money and trust me with it. Let me do what I'm going to do. And so there's that balance, just like everything else when you do estate planning. You have to take into consideration those practical aspects, but you also have to take into consideration those emotional aspects too.
100%. Well, that brings me to another mistake that I think people make, and that is not sharing their estate plan with their children.
Yeah.
Not having that family meeting and saying, hey, you don't have to talk about everything you have, but here's how we want our things handled. Here's the trust documents. Here's a list of, here's where you find the list of assets. Here's the team of professionals that you need to call. Giving them information. Look, I'm in my 50s and I have a family meeting every year with my kids, and I say, okay, here, just a reminder, here's where we're at. Here's what we're doing. These are the rules. Mom and I made some changes. Here's what those changes are. And it's important, I think, to, not wait until you're on your deathbed to have that conversation. You want to have that conversation on an ongoing basis because you never know.
You really do. And it's a really good way to make sure that fighting's not going to happen because you're going to say, hey, this is what I want. This is what I have. This is who is doing what. So if the kids are going to be mad at anybody, they can be mad at the dead person. That's not that big of a deal. So again, they can still continue to maintain that familiar relationship of what's happening there.
I want to thank you very much for taking the time to come on the Guided Retirement Show with me and share some of what you see as estate planning mistakes. And I encourage everybody that's either watching us on YouTube, listening to us on your favorite podcast app, get in touch with us and start a conversation with our team and really understand how to avoid a lot of these mistakes from estate planning. So thank you, Tim.
Thank you. I really appreciate the time today.
Thanks again for joining us here on the Guided Retirement Show. I'm Dean Barber. I hope you enjoyed my conversation with Tim Denker. I hope you found it educational and hopefully caused you to think and maybe even take some action.
Starting your route to retirement.
Thanks for watching. Subscribe here to get the latest from the show. Also, be sure to leave a comment and share this episode with your friends.
Investment advisory services offered through Modern Wealth Management, LLC, an SEC-registered investment advisor.